Welcome everybody. It's the 23rd of July 2020. As you know, I'm Mike Eisted, Head of Delivery for Leadership and Management and Facilities Management at Train Together. Welcome to this workshop this afternoon. For the next hour and 25 minutes, we're going to be going over property and asset management. We've just had a little prelim session outside of the recording there regarding setting the conditions going forward with regards to microphone management, if you like, and if you need to zip away, you need to zip away. And of course, this is being recorded in order that you can then rewatch at a later time before submitting work for your learning objective, your learning outcome, or indeed share the work. Now, as ever, before we start getting into the meat of this, we've got a little bit of prelims to do, which is recorded for the sake of those who are not here. The first thing I'm going to do with you, first thing is we're going to move off the first slide. So the first thing we're going to look at one file and Padlet orientation. We're going to find out what you already know. I wonder how we're going to do that, Kahoot. We're going to discuss what a lease is and the differences between a lease and a license. We're going to look at leasehold versus freehold and what is the differences and why. Then we're going to look at the types of lease. Now, the types of lease, before I go on any further, the types of lease actually is a bit like leadership and management and the leadership styles and theories and books that are out there, about 15,000 of them. Well, there are many, many types of lease. We're just going to look at one. You'll be required to go away and find out and come back and brief everyone else up on what those others are. Then finally, we're going to take a very brief look at legislation, because if there's one area which is significantly covered by legislation, it is property. Now, this is a very complex unit, split down into easy to understand chunks, as I've said. But the key secret to this delivery going forward is you. You're the ones with the experience. You're the ones who are dealing with this day to day. Yes, of course, I've got the experience as well, but I want you to come forward and I want you to share your experiences and add value where you can. So just because your microphone's muted, don't, for the love of God, think that unmuting it is something you don't want to do. Your mouse should be hovered over that mute button, ready to unmute it and ask a question or add value wherever you deem appropriate. This is your workshop. I'm just merely steering it for you. Great. Right. Now, clearly, sometimes I've got to stop sharing my screen and then reshare it in order to set the appropriate conditions. So that's exactly what I'm going to do now. Is I'm going to stop sharing my screen and then show you what the Padlet looks like now. Before I do that, obviously on the format it says one file there. To reiterate, the work required for you, your assignment will be set and in your inbox on one file for Monday morning. In other words, it will be done over the weekend. You will have two options. You can write about learning outcome one, or you can produce a presentation in order to present back to me, which will be recorded. Either one of those two ways. The other ways of evidencing your understanding throughout the unit will also be varied, with also a professional discussion and a couple of other ways of evidencing your understanding, including for the first time some question and answers, a question and answers section, which will be on one file. So look forward to that, as I'm sure you will. Right, what is the score with Padlet then? Well, Padlet has had a little bit of a makeover, if you like. And this slide here is pretty much showing you that there is now a new area for you on Padlet. And what I'm going to do now is I'm going to share my screen so that you can see that. Bear with me. Okay, here we go. Share the screen. And that is now shared. So you should be able to now see Padlet. Can someone just give me a heads up that you can?
Yes, I can.
Yeah, thank you very much. Okay, so I'm not sure if you can see my mouse. You probably can't, but you'll see here the familiar sort of tile layout as you land on it. And there are now 4 new slides: endpoint assessment, level 2, level 3, and level 4 current units. Clearly, the endpoint assessment is an area which I would suggest you go and visit. Some of you are coming towards the end of your learning journeys. If you're within between 2 and 3 units outside of the end of the endpoint assessment, I would strongly advise that you go into the endpoint assessment, And here you will see very easily laid out for you what is required of the level 4s for the endpoint assessment. There is the presentation and project briefs here, the guidance for your work-based project, and also the presentation guidance. So I would strongly suggest that you go and take a look at these documents, because as you get into 2 units left, we will then start to address this in tandem and ensure that you're prepared. Back to the main Padlet, and I mentioned these other 3 units. And what I've done now is I've created you a current unit tile. So currently we're learning unit 16. So if you go into here, then you will see all of the appropriate resources that will enable you to answer the current learning of that particular unit. Now, all of these documents here have been created for you. It's all tailored. Everything that you see here is part of this particular learning outcome that you're going to. This means that you can click on the level 4. It means you can come to here, the level 4 current unit, and know that everything that you're looking at here will enable you to answer learning outcome 1. When we go on to learning outcome 2, this will all change. But all of this will go back into a new tile into the FM subjects area, and there will be a new tile here known as property and asset management. So yes, this is your main library that you're looking at now, but ultimately there'll be a new tile being built with all of the current units information being placed in there. You can also see here there is a link here to each of those current unit resources. Hopefully this will enable 2 things. 1, it will expedite your understanding, not just of the workshop, but it will very succinctly point you to the direction of resources which is immediately relevant, rather than resources which cover an entire unit. I think that was 1 and 2. So do please use that. Of course, Jane Wiggins is our FM friend, and remember that these resources I'm providing you are just one small part in your armory, which is research. Jane Wiggins is a big help, and I'm afraid so is the best library in the world, the internet, and you'll be using that today. I reiterate that you're only going to get out of this what you put into it this afternoon, so please do engage with the activities this afternoon. Great. Right. In the delivered FM workshops, as normal, you can see in here. Here is today's. Whoops. Here is today's. Was that someone else coming in? Oh, okay. Here is today's presentation: leases and legislation. Right. Any questions on the Padlet? Cool. Right. Let's now move on to. Let's now set the conditions. Let's now move on to our activity. Let's find out what you know. Here we go. Okay. Oh, crikey. Jeez. Let's turn that volume down. Thank you. Okay. Here we go. Now, where is my... Of course, this is always the thing, I'm afraid, when it comes to workshops, and that is it never goes as smoothly as you want it to, but hopefully this should... in fact, no, that's not it. Let's go back. Okay, so of course you can't see what I can see. Okay, you should now be able to see the Kahoot screen. Can you see that, everyone? Can someone tell me? Someone give me a heads up, guys. Can you see it? Great.
See it,
okay,
Mark.
So as normal, okay, there's your Kahoot pin. Let's find out what it is. Turn that annoying arcade music down. There we go. So as per normal, let's log into Kahoot. I'm logging in myself here. Okay. Here we go. Kahoot. Yellow Leopard is in. Silly Newt is in. Bright Yeti. aquatic sea lion. 1, 2, 3, 4, 5, 6, 7, 8, 9. So there's 9 of us. Great stuff. For those of us who are slightly late, just while we're logging in, not a drama, but I would suggest you watch what you've missed at the beginning. Pretty much, I mentioned some sort of admin regarding. Some admin regarding the course and learning going forward. Mentioned about COVID-19 and those difficulties and a few other bits and pieces. So quite important that you bring yourself up to speed with that. Leave. All right. Okay. Cool. Right. 1, 2, 3, 4, 5, 6, 7, 8. We're just waiting for one more person. Who are we waiting for? Anybody? Now, I'm willing to bet that Tom. I'm willing to bet that Tom Hitchin should. Tom, you're under a bit of pressure here.
Yeah,
Hero
thanks for that,
Owl. Say again.
Thanks for that, Mike.
Sorry, I think you are. I think you're under just a little tiny weeny bit of pressure. Now, before we start, because Karen's here now, I think Jeannie's just popped on. Let's just reiterate, just very quickly. We're going to get out this what we put into it. You've all got a great deal of knowledge when it comes down to property. This is a complex area. This is one limited aim learning objective 1. And we've got 2 weeks to do this work, and then we move on to the next one. And that's why I've done it piecemeal. 1, you achieve it quicker. And likewise on the Padlet, that should help you as well. So let's give this a crack. Let's find out what it is that we do know. Don't worry, guys, if you get these things wrong, if you end up slapping your forehead. Don't worry at all. This is just for you. It's for you to measure what it is that you know. Okay, cool. No pressure at all, except Tom. Poor old Tom. Here we go. Okay, then. Right. Property and asset management. You know how to play it. Your answer on your phone. Look at the screen. That's where your questions are. The main legislation that governs landlords and tenants is the Landlord and Tenants Act 1955, Property Act 2011, Landlords and Tenants Act 1954, which is the bottom yellow one, and Estates Management Act 1976, which is the bottom green one, bottom right-hand side. 12 seconds left to go. LTA 1955 red, Property Act 2011 blue, Landlord and Tenant Act 1954 orange, and Estates Management Act 1976 green. Well done. 4 of you got it right. That's right. Landlords and Tenants Act 1954. Very easy to get it to get mistaken by the date there. And clearly that was a trick. And the one who got it wrong, Estates Management Act. That's perfectly fine. You got it wrong, to be perfectly honest with you, because it sounds about right. And as you'll find when we start talking about legislation, there is a great deal of legislation in property management. Of which you will have to evidence your understanding on some of that. Landlord and Tenants Act 1954, and that will become a constant mainstay throughout this whole unit, and you should understand some basic elements of it. Points to note: solicitors and lawyers and surveyors make their entire career and still fight and try to understand and go to court over LTA 1954. It is a complex piece of legislation. But as ever, I've pulled out what you must know. And so hopefully that will help you. Right, aquatic sea. Who's aquatic sea lion? Don't know. Yellow leopard, hero owl, 817. Wise dolphin, 550. Not off the mark yet, silly newt, and a few other people. Do answer, even if you get it wrong, it doesn't matter. Let's move on to the next question. True or false? The lessor is the owner of a property. Look at that 50-50 split. Yeah, it'd be easy to. I think the easiest way to think of it is an employer and employee. Employer is someone who owns a function, i.e. a business or a service, and as an employee, you're the one that works for them. You don't own the business at all. You just sort of own an appointment in the business for a set time that you're with that business. And a lessor and lessee is exactly the same. The lessor is somebody who owns the property and the land that the property is on, and the lessee is somebody who essentially, for the period of that lease, only actually owns the property for that period. And even then, of course, it's not perpetual. It's not infinite. It's only for a finite amount of time. So actually, the owner of a property is the lessor. Who's Yellow Leopard? Oh, done. Number 3, which may be an incorrect statement for a leasehold property. Incorrect statement for a leasehold property. You may pay for ground rent, service charges, and additionals. Red. Needs formal review and re-engagement. Blue. It's finite in time scale. Orange. It is not covered under the Landlords and Tenants Act. Green. So which is incorrect? Which is incorrect? Yep, it is not covered under the Landlord and Tenants Act. That is incorrect. As I'm sure Tom will be able to add value later. Some properties are in the Act, some properties are out the Act. That's entirely down to the person that owns the property, the deed period, and ultimately the engagement and agreement made with the tenant. Plus, of course, if it's going to be over 3 years, then ultimately there needs to be some form of legal representation. The Landlord and Tenants Act will always give you protections under the provision, as they call it. Yeah, so it's always wise for you as a tenant to sort of get a property that's within LTA 1954. But a lot of properties out there, a lot of commercial properties are not. And if it's not, then, it can become far more complex. Which is not true of a gross lease. Flat fee for using a property. All costs covered except the building fabric. No additional incurred costs. And easy to manage for both parties. So what is not true? Flat fee for using the property, red. All costs including all costs covered except the building fabric, blue. No additional incurred costs, orange. And green, easy to manage for both parties. Which is not true. Well done. All costs covered except the building fabric. If you take out a gross lease, then it's all covered. Now, there are always, usually, I say always and then counter it with usually, but there is, let's say, the majority of the time, always parts of a gross lease which may be taken out of the lease and into an agreement. But a gross lease essentially means that, you've got a flat fee. You pay one fee, that's it. You haven't got to worry about anything else. And for certain types of businesses, there are huge advantages to that. There are also disadvantages, and we'll cover this later on. Aquatic sea lion out there, 1,500 in front. Yellow leopard though, 2,500. Hero owl, 1732, and actually third, fourth, and fifth, pretty good there, not bad. 5 out of 9. Section 25 for the LTA 1954 stipulates the right of the tenant to issue notice of breaking the lease. True or false? It is actually false. It is the right of the landlord to issue notice of breaking the lease under Section 25. Section 26 enables the tenant to issue a notice of breaking the lease, and there is then caveats within a certain time frame, etc., etc. Tom, anything you'd like to add to anything that we've said so far? I meant to come to you after each one if you wanted to add value.
Not really, Mike.
You're the expert.
This isn't actually my expertise, if I'm honest.
Well, there's this broadening because there's other people in your office who deal with this. That's why. Yeah. So Section 25 is the section where the landlord can issue notice of breaking the lease. Oh, Bright Yeti has moved up, overtaken Wise Dolphin. Good news for Bright Yeti. Okay. A freehold property means that You only own the property, but not the internal walls. Red. Blue. You own the property and the land it sits on. Blue. You only own it for 99 years. Orange. Or you own the land it sits on, not the property. Green. You only own the property, but only the internal walls. Red. You own the property and the land it sits on. Blue. You only own it for 99 years. Orange. And you only own the land it sits on, not the property. Green. Yeah, you own the property and the land it sits on if it's freehold. People always get mixed up with freehold and leasehold. We'll cover them later on. They're quite simple, you know. If it's freehold, it's yours forever and the land. You could knock the house down or you could knock the property down commercially and build on top of it if you had the right permissions. But leasehold is something completely different and indeed can have long terms such as 99 years. Aquatic sea lion, more movement in the rear of the field with Silly Newt and Bright Yeti. They're going to fall out in a minute, I'm sure. But way out in front is aquatic sea lion. Yellow leopard, whoever yellow leopard is, doing exceptionally well. Bearing in mind, the only reason why I'm in front is I put it together. Which is not an appropriate legislation for property. So what's not an appropriate legislation for property? Occupiers Liability Act, red. Landlord and Tenants Act, 1954, blue. Estate Agents Act, orange, and the Carbon Reduction Commitment, green. Ooh, the tension. Yeah, it's the Carbon Reduction Commitment, which is an initiative and what they call a directive initiative from the government. In other words, this is what we aim to do. The rest are all acts, and therefore they're all legislation. But carbon reduction commitment, no less important, I might add, than legislation. But because it is an initiative and because it is temporary and reviewable, and that being regularly, it's an initiative and not an act. Oh. Someone's waiting to come in. Okay. Can you put your microphone on, please, John? Thanks, mate. Okay, let's move on to the next question. All right, question 8 of 9. True or false? A tenancy less than 3 years should be made by deed. True or false? Yeah, it is actually true. Actually, that's wrong. I'll tell you now, that's wrong. I've made a mistake there. Or never be afraid to admit your mistakes. Crikey, 2 o'clock. Never be afraid to admit your mistakes. Yeah, that's actually true. That's actually false, by the way. A tenancy less than 3 years doesn't need to be made by deed. So a tenancy less than 3 years should be made by deed being true is actually wrong. So all those who got false is actually right. So that screwed the scores up slightly. But that's my mistake. But there we go. We're all human. Name's Isted, not Intel. Right. I think that was the final question. Oh, no, here's the final question. A license grants exclusive rights to use the property. True or false? A license grants exclusive rights to use the property. Blue is true, red is false. Yep, that's right, it's false. A license does not give you exclusive rights to use the property. It gives you the rights to use a property for a particular function. A lease, however, gives you exclusive rights. In other words, it's yours for that period. You know, even the landlord actually can't have access to it. A license, however, means that actually you may be one of many that has a license. Right, final scores on the doors. Let's have a look. In third place, 3992, Agent Finch. Well done, Agent Finch. Yellow Leopard in second, and out there in the lead, even though he got one of the questions wrong, which was actually right, Aquatic Sea Lion. Well done, Silly Newt and Hero Owl for runners-up. I think your scores actually matched at the very end. So there we go. That's now, you now know what it is you know about property in general when it comes... Goodness gracious me. Okay, someone wanted to come in. I think John's in now. So there you go. You have now got some form of measurement on what it is that you know when it comes down to property in very general and very basic terms. You know, I'm not measuring you on that. I just wanted you to have an idea of what you knew before we even started. Excellent. As ever, I've got to stop sharing the old screen and then reshare. Let me close that. I've now got to close this and restart this. Of course, you can't see any of this, can you? I apologize, bear with me. Okay, cool. I'm not sure if John's in the room yet, but if he's not, then of course it's being recorded. So what I want to share with you now is that screen there. So you should now be seeing the Kahoot screen. Let's move on. There we go, property and asset management. So you should all be able to see that. Can someone just give me a heads up that you still can?
Yep.
Great, thank you. So there we go. The Kahoot thing, very good measurement system, enables you to have a sort of understanding. If you were to do that again at the end of this, which I don't think we'll have time for, but if you did do it again, you would get all of those right. If of course I went in there very quickly and edited that mistake that I made. Yeah, all good. Now, the aim of this workshop, which is a limited aim workshop, is to introduce you to elements of property and asset management, specifically relevant to Unit 16, Learning Outcome 1. I'll let you read the rest. Key thing, and that is that the whole learning outcome is understanding the requirement of property leases, and we're going to be looking at types of leases and licenses, and legislation. And it is the very basic foundations of property understanding. Remember what I said, this is one unit on your course, but property management is a huge area in itself that people make careers of. So my advice to you when it comes down to you creating your evidence of understanding is that you utilize the conditions that I've set for you. You use the Padlet, you use the current unit criteria Padlet that I've created for you. You use Jane Wiggins and you use the library and you research what you need to research for these learning outcomes. If I was to teach all of the different types of leases, the leases and licenses and all of the legislation, then essentially that would take 3 to 4 hours. It's just not feasible. So when it comes to leases, I'll talk to you about one of them, and then each one of you will disappear and find out, or I might pair you off and find out about other types of leases. Likewise with legislation, and then when you come back, you'll have an opportunity to feed back to everyone else. Remember what I said, please help me help you understand. Don't be backwards in coming forwards and engage with it. You'll only get out of this what you put into it. If it's all going to be me, it will be finished in 25 minutes. So it's very important that you do your bit. So open question, and you can turn your mics on now. Open question. Why should a lease exist? Let's discuss it. Why do we think a lease should exist? Let me go. I'm going to pick someone and they can start it off. Unmute all your microphones. Let's go to. So here's the question. Why do you think a lease should exist? And that's to Jen Warren. Jen? That's it. Move your mouse and unmute your microphone. All right. Okay, we'll come back to you. Carolina.
Sorry about that.
That's all right. Jen, why should a lease exist?
So it's some legal background, isn't it? So you've got so you can challenge your landlord if things go wrong.
Yeah.
Some sort of ground rules, isn't it?
Yeah, well done. Well done. It's foundation. It's creating something tangible, something legal. What about what are your thoughts, Carolina? Why do you think a lease should exist?
Was going to say similar thing.
Yeah.
So basically, if there's any issues or you have basically perhaps some sort of drawn agreement, what to look at and how to sort out the issue. So there's basically, that's why.
Yeah, yeah, and without drawing it out, I think you know, you've hit the nail on the head, Jen and Carolina. You know, a lease exists so that there is a fundamental, tangible foundation which has legal representation in order that any confusion or frustrations or queries regarding any provision by either party can be legally represented in a court of law. You know, a lease exists because, to put it frank, it is the law that a lease exists when it comes down to any form of particularly commercial side of things. Now, that doesn't mean to say that a lease cannot be a verbal agreement, but it has less protections for the tenant and for the lessor, for the owner, if you like, if there is no written lease. A lease does not have to be written. As I said, it could be verbal, but you know, you would be surprised, as I was in my own research, you will be surprised the amount of properties out there that are under lease, but as a verbal agreement, usually through friends and family and so on, shops and things like that. A lease, ideally, in order to protect the landlord and the tenant, should be a formalised document. And actually, if it's over 3 years, it has to be made. It is the law that there is a written document that is enacted by a solicitor, that is witnessed and very, very formalised. Now, whether that lease is within the Landlord and Tenants Act 1954 is neither here nor there. But whether the deed stipulates that it's within the Landlord and Tenants Act during the duration of the lease is also something else. But the fact of the matter is, over 3 years, there has to be a formal deed. Any input from anybody? Anybody welcome to say anything if you want to, or we move on?
I think it's sometimes it's also about, if we're talking about landlord and a tenant, so it's all about obligations, so what obligations tenants would have, and then landlords, and then whether landlord is responsible for all the health and safety. And if we're talking about commercial properties, so I believe it's about asbestos and all of that type of thing. And if for the tenants, it's about paying rent.
Yep.
So it's important to have that lease, so it's all agreed and everybody follows it.
Absolutely right. Yeah. And of course, the deed, don't forget, is not necessarily the lease. The deed is the ownership for the period of that lease. The lease can, as Carolina has shared there, the lease can contain all sorts of details, constraints, allowances, and, you know, overt obligation statements on what the landlord must provide in order to remain within the law. So when we say it's the law, there is no one statement that says, or there is no one piece of legislation that governs that. There are a multitude of legislations, a huge amount of legislation in property in general, and they all counter each other. They all not counter. They all partner each other by saying, you know, by saying this: over 3 years, you know, it's got to be made by legal deed. Yeah, cool. And as it says there, you know, if you verbally agreed a 5-year term and you haven't got a deed in place or even a lease, and your tenant, you know, ruins your shop or office building or whatever, or takes a load of internal walls out, they can just walk off the site and you haven't got a leg to stand on at all. So it's almost madness to think that not only is it the law and people bin it, but actually that you wouldn't have some form of, you know, legal agreement in place. Yeah. Some top tips about, you know, why should a lease exist? You know, top 5 reasons they call it. Now, granted, this writing is very small, and so what I've tried to do is create a bit of a summary for you. First of all, it's the law. 3 years or more has to be registered as a deed. If you want to define deed further, look it up, but it's a legal. It's a legal document. It's a legal document that is a legal document for over 3 years. Less than 3 years, then it's been classed as an agreement. That agreement can also be legally held and legally produced by a solicitor, etc. But it doesn't have to necessarily be a deed of transfer of ownership for that property during that period of time. The next part there is about protection. And this is about the use of the Landlord and Tenants Act 1954, particularly for a periodic lease, if it was less than 12 months, month to month, year on year, or even a fixed term over 12 months. The Landlord and Tenants Act is a complex piece of legislation that was designed to ensure that there are no loopholes. And anyone who works or has worked under Landlord and Tenants Act 1954 will know that, you know, if you know the LTA 1954 very well, you can use it to your advantage. And if you don't know it very well, then you're going to pay a lot of money for someone else to come on board and know it very well for you. Insurance, repairs, decoration, and what sometimes is termed as dilapidations, and I'll cover that in a minute. But this area here is why a lease should exist, makes it very clear who is responsible for the insurances, safety, the inspection. And when we say safety, Carolina had some value earlier on about asbestos, electricity, fire. All of these are landlords' responsibilities to ensure that they've met those requirements under all of the relevant acts. The Fire and Safety Order Act 2005, Fire Safety Order 2005 is an example, the electronic regulations, and so on and so on. When it comes to dilapidations, if you've not heard of that word before, then it is a word that you should know when it comes to managing any form of property. Dilapidations is the state of the property when it is returned under Section 25 or Section 26 of the Landlord and Tenants Act inside the Act, or when an agreement comes to an end. It is the state of property given back to the property owner, in this case the lessor, and it should be, and I've never ever seen a lease that says that it accepts it in its current form, it should be back to the original form of when it was originally leased. Now, if you're in a property for 30 years and you come to the end of your lease agreement and you've decided to scale down the business because you don't need 14,500 square feet anymore because COVID-19 hit and you realise actually everyone worked from home and it works. So it just so happens you're coming towards the end of your lease, your break lease, and you've issued a section 25. Section 26, sorry. You've issued a Section 26 and you're going to break the lease, and it's within the time constraints and caveats, which I'm not mentioning here because it can be quite complex. And it's agreed. When it comes to handover day, that landlord will expect that property to be exactly the same as it was 30 years ago. That includes all of the decorations. That includes light fittings, it includes skirting boards, it includes anything that actually might well be upgraded out of normal fair wear and tear. And it is down to you as a manager of the lease throughout the period of the leasehold to engage with the landlord, of which you'll very rarely get a chance to do. Most of the time that will be through a managing agent. But to engage with the landlord and to ensure that any changes to the inside or to the decoration of the property has got landlord's permissions within certain constraints, or at certain time is reviewed for agreement of increasing of changing the inside of a property, for example, internal walls. Very rarely will a landlord allow you to make changes and then include that in the lease as an amendment to the lease, in order that at the end of the lease they can turn around and accept that property as it is with all the changes you've made, because I'm afraid it's a money earner. Simple as that. You know, no one is going to throw money away. And if you've got the money, they say speculate to accumulate, but if you've got money to buy a commercial property, then the majority of your wealth will come from the rents, from service charges, and from dilapidations upon change of tenancy. There is no way of getting around it apart from a very active corporate real estate arm or a very active sort of corporate real estate agent that engages the managing agent or the landlord and ensures that those changes are noted and agreed as the state of the property in order to carry it forward before handing it over. I've handed over properties before, not me personally, but functions of my management have handed over properties for me back to landlords. And I remember on one particular occasion, and I said 14,000 square feet earlier on, it was 14,000 square feet, and the business had had it for nearly 40 years, and that was going to cost us nearly £750,000 to hand that back because it was not the same. We ended up taking an extended tenancy in order to put everything back right again. So, you know, if any of you have had dealings with surveyors, dilapidations experts and so on, and property in general, then everything I'm saying now will be familiar to you. And if you haven't, then you need to set the appropriate conditions that you're at least aware, because you will, your career and your current pathway dictate that you will be in charge of property and everything about that property in your futures. And if you don't understand the importance of the Landlord and Tenants Act and the protection and what lease is and why it exists, and these sections that I'm mentioning to you, 25, 26, then ultimately, you know, you will cost your organisation money, almost to a point of you know, serious critical amounts. Anyone got anything they'd like to add before we move on? Okay, thank you. Okay, next one is about the use. Sometimes in the lease, it's incumbent upon the lessor perhaps to sometimes put in their restrictions or constraints of the tenure, the time that you as a tenant are in that property. And this is in order to protect the property and the surroundings and ensure limited depreciation. Depression, sorry, not depreciation. There is two separate meanings there. Depreciation is of a particular item or location, and a depression is how that affects other properties around you. If, for example, let's say, for example, you took a lease out on a shop in a high street in a village, and that shop and there was no stipulation in the lease as to what you could use that shop for. When you initially engaged with a managing agent acting on behalf of the landlord, you pretty much said, well, I want a shop to sell shoes in. It wasn't stipulated on the lease that the 10-year period is only to sell shoes or other commercial products fitting of the high street. I was going to choose a lovely Kent village like Tenterden or Rotterdam or somewhere like that. If that wasn't stipulated, then 2 years down the line, when your shoe business goes under and you realise that actually selling shoes is not a thing, what should I sell? I know what, I'll sell e-cigs. I'll do e-cigs and e-liquid and all the rest of it. And this quaint little Kent village, or, you know, which is very old-fashioned, etc., and you start selling e-cigs and start having music on, as is now the fashion with e-cig machines, e-cig places, and all of a sudden now you're getting people hanging around outside puffing, and all of a sudden it's now affecting and driving the value of properties commercially around that particular location down, because people aren't walking past your shop anymore to go into the antique shop, because they've got to go past 20 people puffing away on menthol. So and all of a sudden that has a huge effect on the value of retail properties, which are regularly reviewed far more than private properties. Depression value drives down the value of a lessor's property. So this is why it's very, very tightly controlled when it comes to getting a lease for a commercial property. And the final one there is about termination. You know, the lease there gives protection of termination rights by the landlord for late or failure to pay rent, and any other agreeable amounts, as it says, like service charge, for example. When me and my wife bought our first house in Hastings years and years and years ago, there was no mention in anywhere whatsoever. You know, a year into being in the place, and all of a sudden we got a bill through the door for a ground rent charge for cleaners for common areas and a few other bits and pieces, the garden out in the back. Now, this is a 4th floor flat, 2-bedroom flat. And all of a sudden we've got a bill for £1,000 way back in 19 blah, blah, blah. You know, where did this come from? So we took it to a property solicitor and said, you know, this just appeared. And they went through all of our documentation. Never anywhere was it stipulated that there would be a ground rent or service charge, as it's called in the commercial arena. And Tom will add some value, I know, in a minute. So we fought it, and actually we didn't have to pay it. In the end, we came to an ex gratia agreement. An ex gratia agreement is an agreement by both parties that neither party is in the wrong, but there has been a miscommunication at some point. And so what happens is you agree a certain amount to be paid, which is a fair amount, and in the end we end up paying 10%. That little scenario there, whilst real in the private property market, happens all the time in the commercial property market. And this is why the lease exists. As Carolina said earlier on Jen's introduction, you know, it exists for protection. And in the commercial world, well, I'm afraid it's the private sector. And why do businesses exist in the private sector? Anybody? Anyone?
To make money.
Thank you. To make money. That's why they exist. Doesn't stop them loving their product or service, but they exist in the private sector for one reason and one reason only: to make money. Like I said, doesn't absolve them from loving their product or service. And of course, legislation is produced by a government, and a government, of course, are enabled to enact legislation in order to make money on other people's money. OPM. So OPM, not opium. So this is why the lease is so the Landlord and Tenants Act particularly is so formidable to challenge, because almost at every turn it is about protection of money and the earning of it. Cool. So what then, open question to you, is the difference then between a lease and a license? Now we know what a lease is, essentially, and why we should have one. And we know it's a fundamental legal requirement, verbally or written, although always best be done written. And there are protections afforded to a landlord, lessor, and a tenant, lessee, when it comes down to having tenure in a property. Why then, or what then, is the difference between a lease and a license? Anybody?
A license is more likely to be flexible or on a short-term basis. It offers flexibility between the landlord and the lessee. It might just be for certain elements of that particular premises rather than the whole site itself.
Yeah, exactly that. Yeah, exactly that. Does anyone else want to add anything more before I sort of summarise that? But yeah, you're exactly right, Tom. Yes, go ahead.
Is it the lease gives you sole rights to that building, and a license is just part occupant, like only allows you to occupy it part of the time, or for a little?
Yes,
it's not solely yours.
Yeah, that's right. A lease gives you exclusive rights to the property. A license only gives you exclusive rights to a particular function, or even a period of time, or even a certain place. You know, a lease and a license are both types of contractual agreement between the lessor. I'm reading something off of one of your handouts here, by the way. Between the lessor or license, or lessor or licensor, and the lessee or tenant of a license. So this contract binds both parties to the terms of the agreement. Leases and licenses grant permission for using someone else's land or properties for specific periods of time. They may cover a long period of time, but eventually terminate. Each has a different provisions and includes different relationship between property user and property owner. So and that's and I've done that quite a few times actually, guys, from up till now, is I've referred to the handouts that I've created for you that are on your Padlet Resource Centre under the current unit. So essentially, as Jen said, and as Tom said, a lease is a right to possess property to the exclusion of all others. In other words, that's your property for that period of time. Whereas a license is merely a personal right to use a property as an individual or as a group of others. With all of the word license far more than we've heard the word lease. Sometimes we have, so a fishing license enables you to go fishing. It enables you to do a function. A driving license enables you to drive a car. It is not the same as a hire purchase lease or a financial lease, as it's called. It enables you to drive it. It doesn't enable you to own it. And it's the same with a license. A license enables you to use part of it for a specific function, for even sometimes for a specific time period or time amount, whereas actually a lease enables you exclusive rights. Does everyone understand the difference then between a lease and a license? Or anything anyone would like to add? Cool. Microphone administration is really good because it means that I know that you get to hear it and I don't get any feedback and stuff, but it's also quite lonely sometimes. You're not all shouting at me and stuff. Okay, let's go into our next slide before we have a quick couple of minute break. Question for you. Let's keep it here. What's the difference between a leasehold and a freehold property, do you think? Anybody?
A freehold means you own the land as well as the property it sits on.
Well done. Well done. Freehold is about, you own the land and you own the property. And as I said earlier on in the Kahoot game, you could knock the property down if you had the right sort of permissions and build something else on top. That actually is the same, whether that's a detached country house in Nottinghamshire or the beautiful Derbyshire Dales or the hills, or actually whether you're in the centre of Leicester. It just means that the permissions are harder to get and it'd be more expensive, but it still gives you the right to be able to build on that particular ground that you own if you have the right permissions and have complied with the right legislation, locally or nationally. A leasehold, however, does not. Absolutely. So there you go. So there's an example. I know you might not be able to see that. So I'll just quickly zip over that for you. And again, there is an example of this on your Padlet for this current unit. Freehold, you own the property, the land it sits on, and the space above it. Key thing here means you can build higher. Yes, you might need building permission or the appropriate permissions, let's call it, whether that's private or commercial. But the fact is you do own the space above it. Now, if you ever been to, has anyone ever been to a holiday to Greece? Anyone? Anyone? Or to Cyprus? Anybody? Come on, you must have been on holiday to Cyprus somewhere.
Yeah.
Anybody? Yeah, been on holiday to Cyprus. Ever been in any of the local, the proper Cypriot villages?
Yeah.
Yeah. Well, likewise in Greece and in Turkey and in places in Germany and in other countries in Europe, if you go into any of the traditional villages far away from the sort of modern towns and cities, you will come across flat-roofed buildings. You will come across buildings with no roof on it whatsoever, and usually dotted around the peripheries of the perimeter at the top of the building, you'll usually see some metal rods sticking out, or you'll see some bricks. It almost looks like a chimney that's not doing anything, sitting on the edge of the building, and you'll see various different poles and things sticking out of the roof, not all over it like a porcupine, but just dotted around here and there, usually the corners. If you imagine a flat roofed building with 4 poles in each corner, a pole in each corner, let's say. And that is a perfectly legal, perfectly accepted, recognized way by the governments of those countries that says this is a person who owns this property, commercial or private, who intends to build up. And so essentially the building has not been finished, is not completed. And as a result of it not being completed, it is then cheaper for them in their current, not utilities, but current rates and so on. That is normal, accepted, and always has been. Of course, it brings the benefits are for the people that own those properties is that they're able indeed to extend anytime they like up. It's also cheaper for them when it comes to ground and to taxes and local taxes. And it benefits the tenant hugely. It benefits the government of the time because more people are likely to pay appropriate taxes when buying locations like that and move more regularly. Whereas actually, if you put a roof on it, well, that's it. If you put a roof on it, it's going to cost you considerable money to build further up because you've got to remove the roof rather than just carry on building. And if there is a roof on it, then it is classed as complete. So even though you own the space above the house, you do not have an automatic right to build up. You will have to apply for building and planning permission. That is corporate or corporate, commercial or private. You will still have to apply for building permission to build up. If you have a flat roofed building, and there are some places in the UK where that's the case, some of the older buildings, then you do not. You own that space. You do not have to apply for permission. You may have to then comply with certain protections later on down the line, i.e. structure of the building and certification and so on. But you do not have to jump through hoops in order to build up on that property if it's a flat roof. So that is why you go to these places and you see flat roof building, you go on holiday or whatever. Maintaining the building is entirely up to you in freehold. No ground rent or service charges within reason. Within reason. I gave you an example earlier on. Lower conveyancing costs due to simpler ownership contract. On the leasehold side of things, well, the opposite to what to the example Natalie gave earlier. You own the property, the freeholder, landlord owns the land and the building. It's a common form of ownership of apartments, particularly as I gave you that example there. My leasehold was 99 years. But there was nothing in the lease that said that I would be open to a service charge or ground rent. You pay ground rent, service charge and maintenance fees. You do indeed, unless, of course, the landlord is stupid enough not to get their documents written up legally, but do it on the back of their laptop. I don't even think laptops were about in them days. I think they were, but they were like bricks. So whatever it was he used, but it wasn't done legally, in which case, I didn't have to pay the ground rent. The lease is for a finite period. That means a limited period, and will detail the terms of ownership. So that's very clearly. So freehold, it's yours. Leasehold, it isn't. In its simplest term, freehold is yours. Leasehold is not. I'm going to come to Tom before we have a quick 5-minute break. Tom, is there anything you'd like to add, particularly on the service charge side of things? Let's go commercial. On the commercial side of things, the sort of things that managing agents or landlords put in service charges.
Yeah, well, just following on from what you said there with your situation with the ground rent, it's quite astounding how often we come across commercial leases where certain provisions have just not been included, or the way that the service charge provisions have been written just doesn't allow for certain items of expenditure, or even the way it's actually implemented. So yeah, it's just surprising, even though even now today that you see it quite often in leases where they've just not been drawn up as they were intended to be so.
And what about, Tom, when a landlord wants to make an addition to a service charge in a lease? How do you find them doing that? Do you find that they add that in there via the managing agent without any engagement, or how do you find that happening?
I mean, that would be probably down to a re-gearing of the lease. It's not something you can just add in willy-nilly. Obviously, you have to come to some sort of agreement, or sometimes there'll be some sort of horse trades, or meeting sort of middle grounds. But yeah, getting an actual additional clause in there would have to be agreed, and the lease would have to be ultimately altered.
And that is a great segue to the rest of you by saying, if as part of a service charge, a landlord has stipulated that they will provide cleaning of common areas, and you're under a gross lease where you're paying a flat rate, and all of a sudden now that expenditure has gone up and needs review, a landlord just can't increase the rates without speaking to you or without coming to an agreement. And it's unlikely that you managing the property will be doing that, purely because of the legalities around it, the clauses involved, the protection of the Landlord and Tenants Act. The corporate real estate, CRE, is called corporate real estate for a reason, because the majority of those people are property experts, surveyors, solicitors, lawyers, and they all understand intimately. A lease and a service charge list is not a shopping list. You can't just add to it. You know, any smallest change by a managing agent on behalf of a landlord, in that example, because there are very few landlords that manage their own properties, any small change has to be met legally, and it's not within the bounds of possibility that you can turn it down and say no. If they say, for example, right, well, we want to have more cleaning in because of whatever reasons, so it's going to be X amount, we're going to put an additional clause in. Or window cleaning. We don't do window cleaning. We're going to add window cleaning as the service charge, and you are able to turn around through the appropriate people and say, we don't want window cleaning. We have our windows done because it's not part of the service charge. Landlords and managing agents will try and impart pressure on you and almost waive, you know, sometimes almost waive, 25. Section 25, their right to give notice, providing they've got the appropriate conditions for the future of that property, for example, for them to knock it down or to redevelop it or whatever. And they can place you under enormous pressure. And the only way of dealing with pressure is with ammunition and the appropriately trained people. And that is why this is a very legal area. So would you agree with that, Tom?
Yeah, absolutely, Mike. Yeah.
Cool. Right. Okay. Let's have a quick couple of minute break. Give you the rest of my voice, and I can stop this recording, and that'll be part 1. When we come back, we will look at types of leases. And I'm going to give you an example of one of those leases, which will be a gross lease, and then I'm going to send you away for a few minutes to go and find out whatever you can about a specific type of lease. And then when we come back, we'll spend a minute or so with each person just feeding back. You don't have to produce anything. You don't have to present anything. Just use the best library in the world that we have, which is, of course, Google Foo. Or why don't you go along to the Padlet and check out the resources I've already created for you? Everything you need to know is in there. So by all means, go along and have a look at your handouts. All right, then. If there are no questions, we'll have a break and we'll come back in, say, I don't know. Well, I'll tell you what I'll do. As I said to you at the very beginning, how do you know I'm over 49? Because I play music, and that music sounds like this.